Good day, everyone. Welcome to the webinar, Preparing to Sell Your Business, Compliance Issues That Will Affect Your Value. My name is Angie Fiedler-Sutton, and I'm with the Behavioral Health Association of Providers. The Behavioral Health Association Providers, otherwise known as BHAP, is a national trade membership association that provides education and advocacy for behavioral healthcare providers and related entities. Formerly known as the American Addiction Treatment Association, BHAP is the leading and unifying voice of addiction-focused treatment programs. We provide membership benefits such as networking and access to compliance information, educational opportunities such as this webinar and our Certificate in Addiction Treatment Marketing, the CATM, and advocacy efforts to keep those in the industry aware of new laws and regulations that may be coming that will affect them. Working in the behavioral health industry or managing an organization in the industry can be incredibly complex and filled with ever-changing information. BHAP gives you the resources to stay on top of the rules and regulations for your organization to stay compliant. For more information about BHAP, you can visit our website at www.bhap.us. Before we begin the webinar, a few housekeeping details for those of you joining us for the first time. You will be able to hear us, but we won't be able to hear you. That's because we record these webinars so you have access to them later if you need them. However, if you have questions or concerns, you can use the chat room on the lower left. You don't need to wait until the end for questions. We will be moderating them as needed. We'll send a link to access both the webinar and the PDF of the slides via email after the event. And now, it's my pleasure to introduce our presenter today. Nick Merkin is the Chief Executive Officer of Compliagent, a national healthcare compliance consulting firm based in Los Angeles, and one of BHAP's associate members. As part of his consulting practice, he frequently serves as a fractional or interim Chief Compliance Officer for addiction treatment providers experiencing rapid growth, payment challenges, or in the process of merger or acquisition. Nick earned his JD from Columbia Law School, where he is named a Harlan Fiske Stone Scholar and served as managing editor of the Columbia Journal of Law and Social Problems. Nick was also awarded an MBA from Tel Aviv University's Recanati School of Business and a BA from the University of Pennsylvania. A member of the California Bar, Nick is certified in Healthcare Compliance, CHC, and Healthcare Privacy Compliance, CHPC, by the Compliance Certification Board, CCB. Nick, thank you for taking your time today. With that, I will hand the webinar over to you.
Thank you, Angie, and welcome everybody. Thanks for being here today. As Angie mentioned, the subject of this webinar is to talk about the different risk and compliance issues that may be relevant to either the sale or acquisition of a healthcare business. This is sort of specifically geared to behavioral health and addiction treatment providers, but actually a lot of what we'll talk about this morning or today is relevant to to almost any kind of healthcare transactions. And what I want to present to many of you is some approaches if you are a buyer or a seller to addressing those things. How, if I'm trying to sell my healthcare organization, if I'm trying to sell my addiction treatment facilities, my behavioral health organization, what can I do to increase value? And if I'm buying, what do I need to look for? What are the traps and the pitfalls when I do due diligence? And I'm making an investment in an organization, what should I be looking for to ensure that the value that I think I'm seeing is still going to be there, and how does compliance impact that? So I'll start with a bit of a story, or really just a, kind of a trajectory of the work that I do and what we're seeing here in Compliagent. As Angie mentioned, I'm a healthcare attorney by background, and I spend most of my time working to help healthcare providers build out their compliance programs and their compliance infrastructure. And I spend, in that capacity, a lot of what I do is serve as either a fractional or interim or outsourced compliance officer for different kinds of healthcare organizations, addiction treatment being a big focus of mine. And what I've been seeing, I've been kind of working in this way for about 6 or 7 years. My sort of previous life, I was a healthcare lawyer on the defense side. So I did a lot of litigation dealing with government investigations and sort of third-party claims against healthcare organizations. But I started doing more compliance and advisory work about 6 or 7 years ago. And what I saw then is that a lot of what was driving the work to us was enforcement. There there was and still is a good deal of government enforcement. The addiction treatment industry in particular is driven by that. For many, many reasons, it's an industry where abuses do exist, and in commercial payers, government payers, and all sorts of government enforcement organizations, like states attorneys general, city attorneys, even you name it, have their sights on the industry. That is still here. But what has changed a lot, and what I'm seeing as what's driving more interest in the work that I do and the work that we do at Compliagent, is value, is mergers and acquisitions. It's that if I invest as an owner in compliance, or if I am alert to these things as a potential buyer of a healthcare facility, it's going to mean money to me. I'm going to be able to increase the value of my organization. So people are coming to us more and saying things like, hey, I'm trying to sell my facility. My banker, my lawyer, my M&A advisor are telling me I need to put in a compliance program and start putting in elements of compliance infrastructure, because whether it's a private equity buyer, whether it's just a smaller group, that's one of the things that they're looking for, and that could literally make $1 million difference in the value of my organization in terms of the sale price. So that's a little bit of the genesis behind what I'd like to talk about today, and kind of how I got here and started thinking about these issues. So I want to just start kind of with the end, right? Why is evaluating compliance effectiveness during the due diligence process for a healthcare organization so important? There are a lot of reasons, but really they all come down to value, okay? What is the organization that you are acquiring or selling worth? And like any kind of M&A, a buyer is going to, in trying to assess pricing or trying to assess the value of an organization, look at things like revenue, right? It's typical that you look at things like, the last 2 years, 3 years, 12 months, whatever it is, of EBITDA, of earnings, of top line revenue, of expenses, and things like that. And what I want to show you a little bit today is the healthcare environment is a unique one. And while these things are important in almost any kind of M&A, whether I could be selling, a car company, a retail store, a restaurant, that's certainly all true. There are unique features to the healthcare industry, and specifically within addiction treatment, that create a very close nexus between the value of an organization and its attentiveness to compliance. So what do I mean by that? Here are just some of the unique features of the addiction treatment or behavioral health M&A world. And again, this applies to just about any other kind of healthcare transaction, and obviously there are nuances of all of them. And we'll talk about these three. One is successor liability, right? The idea that I might buy an organization and then inherit the debts, liabilities, penalties that may arise because of the actions of my predecessors. Another thing is overpayment recovery, and again, this is something that I may have revenue that I'm looking at that was actually an overpayment. We'll talk about what that means, and I may have to disgorge that revenue, and also it may not be giving me a realistic picture of what true revenues are, because a lot of those revenues were either overpayments or came in a non-compliant way that's not going to be sustainable. And third, related to all of that, predicting future revenues. Again, if my predecessor in the organization that I'm acquiring, was conducting business in a non-compliant way, let's say they were, doing something that runs afoul of, a statute that prohibits paying money for referrals, right? I may not know that. Obviously, that's not something they're going to talk to me about in the pitch, but that may have been the basis for millions of dollars in referrals that they got over the years. I'm looking at that revenue on the books and thinking, well, the organization is worth this, look how much revenue it has, but again, that might not be sustainable even outside of the successor liability that I might have for fines and penalties associated with this. So to underscore that, let me give you a couple of examples, right? So this is what happens if you don't do compliance due diligence when you're making an acquisition. Two cases from 2017. Quest Diagnostics, a testing lab, settles with the DOJ for $6 million to resolve a lawsuit regarding improper kickbacks, right? So I paid someone to give me a referral, is likely what the case is about. And those kickbacks, by the way, though, were not provided by Quest Diagnostics. Quest actually acquired an organization called Berkeley Heart Lab in 2011. 6 years later, they're writing a check for $6 million as a result of a DOJ investigation because they bought something that was tainted with those kickbacks, right? So I can guarantee you they overpaid for Berkeley Heart Lab because Berkeley was making money, in an improper and an illegal way. So they got hit on one end because they overpaid, and two, they're writing a check for $6 million now. They probably wish they had looked a little bit deeper into that and seen, what we'll talk a little bit about this later, but, what was Berkeley doing? And we'll talk about how we can find that out and give ourselves some assurances. Similar case, Genesis Healthcare. Genesis is one of I think the largest provider of skilled nursing services in the country right now. They paid $53.6 million to resolve claims that they had provided medically unnecessary services and substandard care. Again, not something that Genesis actually did. It wasn't their conduct, but this was conduct that was alleged to have been provided by entities that Genesis acquired years earlier. Once again, writing a check for $53.6 million for something you didn't do. All of these allegations in these cases are related to the target's pre-acquisition conduct. Now, again, there's ways we can try to ensure in due diligence and discover that kind of conduct occurred, and that might scare us away from making that acquisition. And there's even ways that we can document in the transaction some safeguards that we'll talk about in a few slides to avoid that kind of thing. But again, can't emphasize enough. Be careful what you buy. Not only might it not be worth what you're paying, it may sting you even harder because it may be coming to you with some liabilities like that. Another issue, overpayment recoveries. So we mentioned this a moment ago. So commercial insurers and the addiction treatment industry is, very typically one of the major payers is commercial insurers. About 3% of claims volumes winds up getting recovered as overpayments. And there's different kinds of reasons that an organization might have gotten overpaid. I won't go into the details. Nickel and dime error, case rate error, improper coding. Basically that you billed for something that you didn't, either a service you did not provide or wasn't necessary or you didn't have authorization to do, or it was care that was delivered poorly. All of those things can be overpayments. And the overpayments might have even been accepted unintentionally. But all the same, you can be forced to disgorge monies back to the insurance company, and this can even happen years later. So again, at the due diligence phase, when you're making a determination as to the value of what you're buying and looking at things like, what's the EBITDA the last 3 years in financials, this is something that can come back to hit you as well. So again, similar to what we talked about previously, this could be a case where you're one, overpaying, and two, are going to be forced later on to disgorge and reach into your bank account and pay back these insurance companies, these commercial carriers, for their overpayments. There's a process that's involved in this. I'm a little bit too detailed to go into right now, But if anybody has any questions on the overpayment recovery process, it's certainly something that I'm happy to address sort of offline on an individual level if people want to contact me afterwards. So last thing, predicting future revenue. And this is, sort of related to the two issues that I talked about before. But as a third issue, I want to say, again, if past revenues arose from billing that was fraudulent or some kind of non-compliant or unethical practice, how accurate are the financials that you relied on in making your acquisition decision? Setting aside fines, penalties, and other liabilities, I may be looking at financials that are simply not accurate because they're reflecting monies received that I'm never going to get once I take over running the organization, because I'm not going to do those unethical practices or those non-compliant practices. And then, here I am overpaying potentially by millions of dollars for an acquisition that I just made. So these are things that are somewhat unique to the healthcare space and certainly specific to addiction treatment as well. And there are things that are worth thinking about. And we'll go into some other due diligence issues in a few minutes. So, how do I address this as a buyer? How do I address this as a seller? So, as most of you are probably familiar, very typically when a buyer enters a phase of being interested in closing an acquisition or a merger with a target, there's a due diligence phase. So, in many cases, we set the price already, or at least how the price is going to be arrived at. And I'm a serious buyer, so I have an opportunity to kind of kick the tires, so to speak, right? To make sure what I'm buying is something that superficially look to me, not only superficially look to me good from the outside, but I get to open the hood, to continue the car analogy. I get to open the hood and sort of look inside and really tinker with it. And if I'm a seller in that space, you can be sure that a sophisticated buyer, or the attorneys that are working with that sophisticated buyer, or even the organizations like the banks or whoever's extending credit for the transaction in that situation, is going to be looking at particular due diligence issues. So here's an opportunity to avoid loss on one hand if you're the buyer, but also increase your value if you're anticipating these due diligence issues and work to resolve them. So a couple of healthcare specific focus areas. And again, much in M&A is similar whether I'm selling a restaurant or a car dealership or some kind of manufacturing plant, but there are unique features to healthcare that are worth thinking about. So number one, government investigations, and also key tab litigation, whistleblower litigation. So when I'm going into due diligence, I want to be asking questions about, are there current government investigations? Certainly. Are there current whistleblower litigations going on? Certainly. But what happened in the past? Even if those cases are resolved, I want to know about them. I want to know how they're resolved. I want to know if the root cause that led to those investigations or that litigation or enforcement action, whatever it is, I want to make sure that that was addressed, so that I can assess, in a practical way, how relevant or what the chances are of that kind of issue recurring again. So that's one issue. Compliance program effectiveness, I'll put that aside for a second because we're going to talk about that towards the end today. Coding and billing, again, depending on the industry, I want to look at things like the policies and procedures that the organization might have about coding and billing and how they're doing it. I may want to bring in an expert from the outside to take a look at samples of their billing and reimbursements and get a sense of how it's being done. Is this sustainable? Is this something that I'm likely going to see revenue from going forward? And is there, kind of within this billing, things that are making me nervous, that might make me liable for an overpayment down the line, that might make me liable through successor liability for some kind of, government fine or penalty regarding, to give the example again, paying a bribe or a kickback or something like that. Referral source financial relationships. Hard to get at, but important. Number one, if they're legitimate referral sources, are they going to stay with me when I acquire the organization, or are they going to go with the previous owners? What are they going to do next? Number two, are these proper referral sources? Beyond the scope of what we're talking about today, but there's all sorts of reasons that a referral relationship might be improper. And I want to make sure if 50% of the revenue I'm looking at on the books is coming from a particular referral source, well, is that something that's compliant? Because if it's not, again, I have cause for concern. Things like prior HIPAA breaches, privacy and security compliance, what are my liabilities there? Number one, what technology platforms, if this is relevant, what are my policies and procedures looking like? How well is the staff that I might be acquiring with my acquisition versed in privacy and security issues related to healthcare? If you're in behavioral health, there's even some more stringent requirements than a typical healthcare organization, and it behooves you to know about them. So do your diligence. Look at, are there prior HIPAA breaches? And by the way, if your target can't tell you, if your target hasn't documented any in the last 2 years, 3 years, 5 years, that's cause for concern in and of itself. Because if they're not tracking that, there's a good chance that they're happening and not being addressed in an appropriate way, and you're going to have your potential for successor liability with that. Or you might have to spend a lot of money post-closing to fix problems and get your organization up to speed. Does that mean you can't buy it? No, it doesn't mean you can't buy it, but I'd probably pencil in some expense or reduce the purchase price, out of concern for some things like that. Excluded or sanctioned employees. As most of you probably know, depending on who you're getting paid by, there are lists of people who cannot work for your organization. That's because they've been put on an exclusion list or a sanctions list because of misconduct that they've been involved in the past. You would be surprised, but they don't often mention this in interviews when you're interviewing them for a new job. There is a chance that if you work with those people, and sometimes they may work for you for years, that you would have to disgorge all revenues from any kind of interaction that they had with a patient, client, whomever, back to the payer. Not to mention fines and penalties for having an excluded or sanctioned employee on your staff. Make sure you are satisfied with how the target is, managing that. Are they actually looking to make sure that they haven't worked with excluded or sanctioned employees? Ask your target for a past employee list. Run them through sanctions checks and exclusions checks. Easy to do, cheap to do, doesn't even take that long, a lot of ROI as a benefit. Think about things like HR issues and whistleblowers, right? A big expense for healthcare organizations, even completely outside of the substantive issues of healthcare, are HR issues. Very, very, out here in California, and I don't know where all the listeners are from, but we've gone through in recent years a lot of change and a lot of scrutiny as to classification of employees as either independent contractors or full-time employees. A lot of organizations are getting hit, particularly healthcare organizations, because healthcare organizations, especially in behavioral health, tend to hire people non-full-time and wind up with issues regarding misclassification allegations of employees. Things like I-9s, things like making sure that someone that you're working with is, has the proper documentation to work for your company from an immigration perspective or anything like that. Again, big issue in healthcare because there is a scarcity of qualified employees, and very often people make mistakes and misclassify or hire people that they shouldn't, or have people who are excluded, who look like they have good resumes but engaged in misconduct in the past, make sure you're looking at those HR issues, and think to yourself and consider what liabilities you might have there. So bottom line, right? If you haven't gotten my message so far, a compliant organization is going to be a more valuable organization. So far, a compliant organization is going to be a more valuable organization, whether it's to you as the seller or whether it's to a buyer. And so it behooves all of us in this space to not only make sure at the time of acquisition that I'm doing this kind of thinking and implementing compliance infrastructure and making sure that I'm maintaining a good risk management program, but don't wait till then. Increase the value of your organization by investing in compliance earlier on, so that when the time to sell comes, or you're being approached by a buyer and they ask you, hey, show me what you've been doing about your privacy training the last 2 years. Let me see the lists of all the people who attended, or show me your policies and procedures related to billing. I want to make sure they're compliant, that you're not giving them a deer in headlights look, because that is going to make them have the potential to move on, or certainly write down the value of your organization in an acquisition. So what do I do about it, right? So I think we've passed the point of underscoring why this is important, and let's talk about a good way to do this. So I actually want to start by talking a little bit about kind of an offense-defense analogy, sword and shield, right? So very often I come, as I mentioned in the beginning, from very much a defensive orientation, right? I'm a healthcare lawyer. I did a lot of litigation defense work within healthcare prior to doing the kind of compliance infrastructure building that I do today. And I very often see things in terms of, well, if I ever needed to defend this in court, what do I have, right? And the answer to that is documentation, documentation, documentation. Whatever I've done, if there's not a paper trail leading up to this, I'm going to have a hard time proving it. So we'll talk a little bit about the right ways to do that and some best practices. But there's another element to that, and sort of another hat, right? So that's what I call shield. And there's also sword, right? That by doing things like compliance effectiveness reviews, by doing things like making sure that I'm training properly, that my policies are where they should be, that I have effective communication within my organization, I'm going to solve problems by doing that. And that's, kind of what I call my sword, right? And that is, both of those things are areas that are going to increase your organization's value. And both of those things are things that, if I'm interested in acquiring a behavioral health organization, that I'm looking at and getting a sense of what the organization has been doing in the past. So there's things you can do pre-closing, and I won't get in too deeply, because these are conversations to have with the attorney who might be representing you in the acquisition or in the sale. One is having representations and warranties, and making sure that the target is warranting that they've self-disclosed things they needed to disclose, that they've made repayments of overpayments and things like that. Another issue, setting up indemnification clauses, where you're saying to the seller, if I get hit on something that you did 2 years after acquisition, well, there's an indemnification clause in this acquisition agreement, and you're going to have to pay me back. Or even better, let's set up an escrow. You're going to put X amount of dollars in escrow. I can't touch it. You can't touch it. But that money is going to be available if an enforcement action arises, an HR claim arises for something you did. And if it doesn't happen, well, that money goes back to you after whatever number of years, however much time. But I know the money's there. I don't need to even worry about chasing you for indemnification down the line. So again, talk to your M&A lawyers about how to set things like that up. Another thing is just modifying the deal structure. if I discover things through my due diligence that give me concern, well, it's all risk and reward. I might say, you know what, I'm no longer willing to pay 10x for you. I may only be willing to pay 7x because I'm concerned about some of the risks that I'm going to be buying with this. There are also ways, and again, complexity of this is a little beyond today, having an asset purchase versus an equity purchase, right? So I may not have to acquire as much of that liability because I'm just buying, the physical assets of the business, or spinning off a part of that organization, so I'm not acquiring, again, the liabilities that are associated with the other part of the organization. So there are ways to manage this pre-closing. Discovering things in due diligence that gives you concern doesn't have to end the deal. And if you're a seller, it pays to be familiar with some of these things because, you want to be able to give your prospective buyers, your potential buyers, a feeling of security and safety in what they're buying, because that's going to induce them to pay more for what you're selling them. So it pays to be familiar with this stuff. Post-closing, and we'll spend a few minutes on this as well, you want to build a robust organizational compliance and risk management program. And getting back to sort of the shield and sword, or being proactive versus reactive, right? Your return on investment is going to be much greater if you're proactive about these things. Don't wait till you're in the middle of an enforcement investigation or one of your employees files a whistleblower suit against you. We'll talk about some of the elements of this, but make sure you're dotting your I's and crossing your T's. And I'll tell you a little, just to tell you a story. I had lunch almost a year ago now, actually, with a former assistant U.S. attorney for healthcare enforcement out here in the West Coast in California. And one of the things she told me is the following, which I thought was very interesting. And it, impacts really the way I see enforcement. And she said, a lot of people worry about the big things too much. And you should worry about the big things, right? If you're committing massive financial fraud, well, you should be worried. But one of the things she told me is this is how we at the DOJ, or at least how I approach an investigation. Even though the DOJ is big, I don't have the resources of a big Wall Street law firm. Okay, I have one investigator and I have a stack of files on my desk, and there are things that have been flagged for investigation. And I hand one of them to the investigator, and I send them out. And what I'm looking for is not the 2-3 year trial for tens of millions. That happens sometimes. But what she said to me, and I think this is interesting because this is very similar in orientation to a contingency lawyer, doing a wage and hour case or a medical malpractice case. She said, I just want easy wins. I don't need it to be the $50 million case. I want to be able to start an enforcement action in the $500,000 case and get a settlement in 2 weeks. That way I don't have to go to trial and spend all my resources on that, and that's how I get promoted. And if you're a contingency lawyer, that's how you're making your money. Yeah, it's great to get the $50 million judgment, but that takes you hundreds and thousands of hours of work to get. Much more efficient for you to be able to identify a problem, attack that smaller problem, and then wind up getting a quick settlement on it, whether you're on the government side, whether you're on the contingency lawyer side. And what she told me is, my investigator doesn't come in and ask the big questions like, hey, let me see 90 boxes worth of your billing for the last 10 years so I can find some billing fraud. My investigator asks really simple questions. Where's your privacy policies and procedures? Show me your HR files. Show me your I-9s. Who are these employees? Do they, how are they classified? And what she said to me is, when I see smoke, I know there's fire. When I see an organization that is, that's not being attentive to details in those small things, and not having that is not a capital offense, but I know that's an organization I should dig into because there's going to be that bigger case there. Alternatively, when I see an organization that when I ask my investigator asks those small questions, they've got it all. Boom, boom, boom. What do you want to see? This policy, that policy. Oh, it was updated 6 weeks ago, and here's the signatures on that. And we trained our staff on the amended policy 2 weeks ago, and here's a list of everyone who attended that training. When I see that, I know I'm not going to bother because I only have a limited number of hours. So that's how I approach things. So I think it really informs the way we think about risk management and compliance programs, and I'll tell you a little bit what I mean. So here are some elements of what I would consider a robust addiction treatment organization's compliance and risk management program, right? And we'll talk about each of these one by one, so I won't spend time right now talking about it on this slide. But number one, have some type of risk management officer, compliance officer. It's not the title that's important. What it is there should be a designated person in your organization who is in charge of this. It could be the CEO, the owner, the president, often not the best person to put in charge. It should be somebody who, number one, has the experience and background that allows them to be the person responsible for making sure policies and procedures are where they should be, making sure that trainings are going on and they're being documented when they should be, making sure when an employee or a client or a client's family has a grievance that gets resolved, making sure that when the government comes in and tells you you're doing something wrong, that you're writing a plan of correction in the right way. So, and that person, again, doesn't matter the title as much as everybody knowing within the organization, that's the person I need to go to. And that person has some degree of authority, right? That they can reach out to the organization's, governing body, if there is one, or the CEO or the owner or senior management, that there's some communication there. And be careful who you appoint. I'm saying, in that slide, ask me about compliance officers and your level of risk. What you don't want to do, and what is in fact even worse than appointing anyone at all to that position, is appointing someone who's not qualified or really doesn't have the time to do the job. Because, let me tell you how that sounds. The investigator, the mythological investigator that I just talked about comes into your organization and says, let me speak to your risk management officer, your compliance officer, I see you have one, talks to that person, and that person doesn't know what they're talking about, isn't really doing their job, tells the investigator, you know what, I wear 4 hats in the organization and I just have too much to do. That looks a lot worse than having somebody at all, than not having somebody at all. So, if you're going to do this, and I would advise it, make sure you've got the right person in place and that person, knows what they're doing and is adequately trained. Policies and procedures. Have things in writing. This helps you in a lot of ways. One, you may have to produce this at some point and show this to a potential buyer, show this to an enforcement official. Some of these are required by law. At a minimum, and it also allows you to hold your employees accountable for following them because you require them to train on them, you require them to be familiar with them. And if there's a violation of one, it gives you what you need in terms of cover if they need to be disciplined, terminated, or whatever. So at a minimum, have things about false claims and billing properly. Have policies about gifts and inducements and marketing. That's a big area, particularly in the addiction treatment space, where organizations get in trouble and pay fines and penalties. Have a policy about referrals. What am I allowed to do? How can I treat a referral source? Who am I allowed to accept a referral from? Have HR policies like personnel issues. Have privacy policies. The addiction treatment and behavioral health industry is one where there is a lot of sensitivity for very good reason to the privacy of your clients. Make sure that you have good policies in place around that. And one other issue, client financial responsibility. What I mean by that is things like co-payments and deductibles. Make sure that you're collecting those, There are sometimes situations where it would be appropriate to waive those. If you have a sort of charity care policy or something like that, make sure you have an actual policy that's defensible, and you don't get into a situation where you're being accused of inducing people to use your facilities as opposed to a competitor's, because you're waiving the client's financial responsibility in areas like co-payments, et cetera, et cetera. I see I've got a couple of questions. I only have a few slides left in this area, so it might be worth it. Let me finish up the presentation, and then I'll try to do the questions at the end, because I don't want to run out of time. So a little bit more on policies and procedures. Have a document, a descriptive document, to show internally and externally that talks about your compliance program, its infrastructure, risk management program, whatever you want to call it, and have a roadmap. I call it a compliance calendar of different things that you plan on executing during the year. Like, every 6 months we're going to have a meeting and review our policies and procedures with senior staff, department heads, whatever it is, make sure they're what we need. We're going to conduct quarterly trainings on things like privacy, on things like billing, on things like relationships with clients, on things like HR issues. Not doing those is important because you want your staff to be educated the right way in those, but maybe even more important, again, this is my orientation, having that calendar and documenting that you're doing them. That's going to be very effective for mitigation and defense if you ever get yourself into trouble with some of these issues. And to be perfectly candid, we all get into trouble. It's a tough space to operate in. There's a lot of enforcement pressure, and you want to make sure you have that. And your ability, going back to the overall theme of this, which is increasing the value of the organization, your ability to deal with the issues correctly as they come up is going to drive up the value of your organization. Mentioned this already, but staff training. If you have policies and procedures, make sure your staff understand how to execute on them. Make a training plan, like I said, where it's proactive, where you're giving trainings throughout the year, and that there's some room for reactiveness, where somebody notices, you guys aren't doing this well. Let me make sure that the policy is clear enough. Let me make sure that you understand that. Again, cross-examination sounds pretty bad when your staff isn't properly trained. If you've got a policy that says, no relation, or limits relationships between staff and clients, let's say, for example, if you haven't trained on that policy and that issue comes up and cross-examination happens, and the employee or staff person is asked, don't you know about this policy, and say, you know what, maybe it exists, I've never seen it, no one ever talked about it, that looks worse than even having the policy, not having the policy in the first place. So make sure that your staff know where to find things, know where to ask questions, and to whom to ask questions if they have questions about things that are governed by your policies. Effective communication. I'm a big fan of one grievance hotline. Whether that's an email account, there are web-based things that can be done like that, whether it's just a voicemail box that gets forwarded to your compliance officer, whoever's running that for you. Make an avenue of communication between both employees and management. And people I talk to, or owners that I talk to, are often worried about doing this because they say to themselves, well, if I give that avenue, everybody's going to complain, right? It's like a complaint box, and I'm going to cause problems. My experience is exactly the opposite. If people have complaints, if they can't vent them to you, they're going to go ahead and vent them to, some friend of theirs who's a lawyer who says, there might be some money in it for you. Or they're going to get really upset and call a state enforcement agency and say, my employer's doing this, I think you should look into it. If those calls, if that expression of dissatisfaction by your employees is coming to you first, then you can address it. They may not always be right. They may most often be telling you irrelevant things, but at least you're getting that information And if it's something relevant, you can address it before it escalates. Most of these things, from the complaint side, wind up not being big deals and can be addressed if they're caught early enough on. Another issue is have that line of communication available for clients and clients' families. Again, similar idea. If they don't know, if they don't have an appropriate way to vet, they think, the food's not good, they think they aren't being treated well, they think they've been talked to abusively. If you don't give them that opportunity to vent to you, they're going to go outside. And I can promise you, if they go outside, there's going to be a worse outcome because you can no longer manage that outcome. And unfortunately, there's money in it for people to press those claims against you, as we've talked about. A couple of other elements, internal auditing and monitoring, right? So have things like formal reviews of your compliance activities with the state with some standards as base measures, right? Start with what we've discussed today. Audit whether people are attending the trainings they need to attend. Audit your billing and make sure that you're satisfied with, your reimbursements, what you're billing for, what you're getting. Monitor things. Have performance reviews for your employee. Include their conduct with compliance-related issues in that performance review so that, one, you can pick up when things aren't right and give yourself the cover to discipline or terminate if necessary, and document that. Again, and I spoke about this a few minutes ago, it is not enough just to do these things. You've got to document that you've done them. If you haven't, then it's almost as if you didn't do them, because a year from now, 2 years from now, the employee that did some of this might not be with you anymore. You might not be able to find them. And if you don't have the documentation that proves that you did it, you're spending resources on something that isn't going to ultimately help you all that much. So please do make sure any of these things, you have to make yourself a little bit anal, I guess, if that's the right word, but document it. Create a culture of compliance in your organization. Have things like a code of conduct, mission, vision, value statement. Enforce those and be consistent and fair about them. Make sure people realize that they get promoted or demoted or fired or, bonused or compensated based on them. And lead from the top, right? If you're expecting your employees to conduct themselves or your staff to conduct itself in a certain way, make sure that you're acting, in a way that's consistent with that, and your senior leadership is acting in a way that that you're interested in, or that is consistent with that. Last thing, have a response team in place for compliance violations. Usually your compliance officer that I talked about back in, sort of element 1 would lead that team, but, that person's not going to be an expert in everything. So you might want to have somebody who is more clinically oriented on that team. You might want to have, if there's someone who does your IT or something like that on that team, you might want to have the owner on that team, the head of HR, whoever your organization is built. Meet regularly to assess, hey, how have things gone the last 30 days or 60 days or whatever it is, and what's our plan going forward to resolve anything that's come up? Make sure that people know that they can access resources who can help them, whether it's within your organization or outside of your organization. If they need help with some of these things, they need to know that. So those are, the elements, and you guys will have copies of these slides, I believe Angie mentioned afterwards, but those are the different elements that I think are pretty relevant if I were, advising you pre-M&A or even post-M&A to build out for your organization. Again, if you're pre-M&A, it's going to add value. If you're a seller, well, it's going to increase the price that you can charge. If you're a buyer and you're looking in diligence at the right things, then it's going to inform how much what you're buying is worth. If this is post that M&A, well, you're still building for yourself a more compliant organization that, again, hopefully is going to have increased revenues and growth and make you money in the long run. Does anybody, does anybody have any questions, regarding what we talked about over the last almost hour that I could address?
While we wait to see if there's any questions, I want to thank Nick Merkin for presenting today. Thanks as well to everyone in our audience for participating. Are there any further questions?
If people have questions, afterwards that are more individual related, my phone number is there, as well as my email address. I'm kind of laughing that my fax number is there because I don't think I've received a fax in like 4 years. But
some people still use them.
The best way to. All right. Well, thank you everybody for attending, and okay. I hope you find that helpful. And all right. Well, thank you everybody for attending, and I hope you find that helpful. And again, happy to connect offline if there's if there are things that make sense to discuss. Well,
we hope that you join us for future BHAP webinars. You can sign up for our various newsletters, which include emails specific to upcoming events at our website, www.bhap.us. We also do provide help on mergers and acquisitions. Check out our website for more information. We also are keeping a list of COVID-19 resources for behavioral health people, not related to this, but related to the current situation. Without any ado, this concludes today's webinar. Thanks again.